Stay away from this place.
What I'm supposed to do? I'm trying to take care of my nieces and nephews, running back and forth to and stuff.
Are you ready?
Yeah, Chapman Judge. If I could borrow a prosecutor. Come on, Mackenzie. You let him do it. It's going to be Mackenzie's first trip to the rodeo, Judge.
Stay.
Stay? Oh, mistake?
Clip 1.
The state.
Let's stay. Okay. Sorry. It's this member of the state. First time at the rodeo. I have Mr. Franklin. I keep trying to reverse his name, Judge. So we were here for one bond violation report, which I don't think that one actually got filed. I think you had just requested it. He had picked up a new case, no PC'd, state dismissed, but the new case involved him possessing, though not using, a kitchen knife. And so the bond conditions.
I didn't ding him on it, did I?
This burn. First trip to the rodeo is code for this prosecutor being green, and the judge isn't sugarcoating it. If you're wondering whether that's common in court, nope. This judge has jokes and no filter. Stay tuned.
Well, you had asked us to come back today to address the fact that he had.
Oh, right.
Kitchen
That he had the knife. Correct.
Yeah. So not that he had potentially committed a crime, but that he had a kitchen knife when he was ordered not to have a weapon.
Guys, I need your help. Come up, Mr. Ladon.
And so
Come up, Mr. Franklin.
when you informed me this morning, I think I'd been sent the email, there's a bond violation report for a GPS exclusion zone. I looked at.
I want him so he can.
Yes, Judge. I'm going to stand between the state. Yes, Your Honor. No, Your Honor. Arms by your side. Whatever he asks you, answer truthfully but briefly. Keep your response brief and do not get excited, okay? All right. Yeah, let me peel this out of the way.
The initial reason that we were here today was because of the case that you picked up that I found no probable cause and that I had an issue because they were alleging that a knife was, I guess, allegedly in possession or whatnot.
The allegation is possession. There was no allegations of use or threat. It's just that he had a kitchen knife on him.
You are on bond for a
Terroristic
threat. As part of your bond condition, you had several. You're not to be in possession of any weapons. You have a GPS monitor, and you're not to go within a certain boundary of the complaining witness in this case. It has now come to my attention through pretrial services that you have bond violations. Specifically, Mr. Franklin has not been compliant with his conditions of bond. Client has failed to not have contact with a prohibited person or visiting a restricted location. Client was ordered by the court not to go within 500 feet of the Northwood Drive apartment in Baytown. On 2/25, client received a victim exclusion zone alert at 10:22 a.m. The victim exclusion zone was cleared at 10:28.
Big one. It doesn't matter if it's a kitchen knife, a steak knife, or a paperweight shaped like a sword. If you're out on bond for a violent offense, any weapon can land you back in custody. It's not about intent, it's about the condition. Well, you had asked us to. Clip.
In fact, what I've been told by pretrial is that we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 instant.
Okay, interject, Judge. I think that's all in a 6-minute window. So I think he crossed into the exclusion zone at 10:22 and out at 10:28. And so I could proffer to the court what was given to me from pretrial. Not that I'm admitting.
Judge has a copy.
Then never mind.
I got it.
In no way admitting that this would be admissible. And looking at what pretrial provided, it looks like he walked about 1,000, maybe 1,500 feet in about a 6-minute window through the exclusion zone. While it says contact, there's no alleged contact with any person. It's just, I know, but it's the way it's written.
How do we know?
Well, no one has complained to the state And so it looks like he walked through an exclusion zone, which is, speaking with pretrial, is actually larger than it normally is. I think it's at 500. Is it 500 feet?
At 500 feet because I didn't want him to go anywhere near the complaining witness in this case.
Yes, Judge.
This is the same complaining witness that we have the last case that I know PC'd.
No, the two are unrelated.
They are different complainants, but.
Yes. And so the terroristic threat was, they're both strangers. The terroristic threat is, the allegation is that my client asked to bum a cigarette, got in an argument when he was denied. And then the newer case with no PC was that some random person's window was broken and somehow my client got charged with it when no one saw or had any evidence to believe that he had done it. But when the police made scene, he didn't have a kitchen knife, I believe, is the allegation. I will say that the new case, it was no PC, but there's also no evidence. There's no offense report. There's no videos because it's a week old.
It's because they didn't go get anything because I know PC'd it.
Well, that's part of it. It's also Daytown and Daytown.
But the problem is that we continue to have issues with Mr. Franklin.
So Mr. Franklin is going to have issues on bond or not, Your Honor. His mental illness is quite severe. He's received hospitalizations in the past. His orange sheet is right at a page, if not over. And so the system is aware. I would take this court or ask this court to take caution in the sense that we're not having a formal hearing. There's no testimony presented. I'm fine with having a conversation. But if the court should wish to revoke
We're
his
having
bond,
a hearing right now.
well, then nothing has been admitted because there was no admissible evidence. I'll find to discuss with the court what has been alleged, but there is no admissible evidence of either location or possession because nobody has testified to either. And I don't think the pretrial services officer in this room would have the ability to testify how a GPS device works. Not to be mean to her, but it's not her job, and so she's not going to have any knowledge of the firsthand knowledge of the device.
We continue to have issues with Mr. Franklin, and I'm tired of it. I'm not dealing with this anymore. I only have one way to fix this.
So I've spoken with the state, particularly the chief. We're leaning towards reaching a resolution on a mental health diversion.
Alerts in 6 minutes. That's not a glitch, that's a GPS device working overtime. Even if there was no contact, just being near the victim was a direct violation. And the court's not likely to see that as an innocent mistake. 8 a.m. In fact, what I've been told by Clip 4.